Welcome back to the Deep Dive. Today we are really strapping in. We're going to take a look at something pretty impactful in patent law. It's about what happens when a patent owner basically says, oops, I made a mistake.
Yeah, we're focusing on a specific part of the rulebook, the MPEP Manual of Patent Examining Procedure. Chapter 1400 deals with correction of patents. And our mission today, to really unpack Section 1460, effect of reissue.
Effective reissue. Okay, so this is about the legal fallout, the consequences when a patent gets formally corrected or reissued.
Exactly. And, the core tension here, for you listening, is pretty stark. The patent owner needs to fix a genuine error. Maybe they claim too much, maybe, importantly, too little. But getting that reissue isn't just a minor edit, it's a fundamental legal reset.
A reset.
Yeah. And the law has this really tough job. Let the patentee fix their mistake, but also protect everyone else, companies, individuals who acted in good faith based on the original patent document.
Okay, that sounds like a tightrope walk. How can the fixed patent be treated like it was perfect all along? But we also protect people who relied on the old, flawed version.
That's the paradox. And MPP 1460 lays out the rules for how this works, how the old patent dies, the new one is born, and how the public's rights are managed right in that transition moment.
Okay, let's start with step one then, surrender. The instant that reissued patent is granted, what actually happens to the original one? Does it sort of fade out?
No, it's much more definite than that. It's a formal, irreversible legal act. The original patent is formally surrendered. Think about it like this. 35 U.S.C. 252 says when you get that reissued patent, the law treats it as if it had been granted in that corrected form right from the beginning.
Wow. So total replacement, it operates retroactively.
Exactly. It's like finding a typo on your house deed, getting a corrected one, and the law says, okay, this corrected deed was the real deed all along since day one.
That's incredibly powerful.
Extremely. And the retroactive piece is why the next bit is so crucial, especially for the patent owner, the continuation of rights.
Continuation of rights.
Okay.
So the law carves out an exception. If the claims in the reissued patent are, and this is the key phrase, substantially identical to claims that were in the original patent.
Substantially identical.
Then the reissue is considered a continuation for those specific claims.
And why does that label, substantially identical, matter so much in practice? Like for the business holding the patent?
Well, it's all about enforcement continuity.
Yeah.
If claims meet that substantially identical test, they keep their effect continuously from the original patent's date. So let's say you're suing a competitor for infringing a claim in your original patent. If that claim survives into the reissue substantially identically, your lawsuit isn't just thrown out.
Okay. So the legal action continues uninterrupted.
Precisely. It preserves the enforceability seamlessly for those unchanged parts. Imagine the chaos otherwise. Every lawsuit would collapse the moment a reissue happened, even for minor fixes.
This rule keeps the patentee's existing rights intact, where the claims themselves haven't fundamentally changed.
That makes a lot of sense. The patent owner gets their retroactive fix, but the parts that weren't broken stay protected through this continuation idea.
Okay, but now we swing back to that paradox you mentioned, the moment of truth for, everyone else. If the patent is fixed retroactively, what about the competitor who looked at the original claims, thought, okay, we're clear, and maybe invested millions based on that?
Yeah, how do you protect them? This must be where intervening rights come in. I see the MP calls this a sort of safety net.
That's a great way to put it. It's the statutory safety net. It tries to balance the patent owner's fix against basic commercial fairness. And the law actually provides two different kinds of protection here.
Two kinds.
First, there's absolute intervening rights. Sounds pretty strong, right?
Ironclad, yeah. What does that cover?
It shields anyone who, before the reissue was granted, had already made, bought, used, sold, or imported something that might now fall under the reissued claims, especially if those claims were broadened. The protection is pretty straightforward. They can continue to use or sell that specific thing, the actual product they already made or bought, without being liable for infringement.
So if I'm a manufacturer and I bought a specific machine before the reissue, and now the reissued patent suddenly covers that machine, I can keep using that particular machine.
Yes, for that specific item, you're essentially grandfathered in.
Okay.
But there's a catch, a technical requirement. This absolute right generally applies to things covered by claims that were in the original patent and maybe were narrowed, then broadened back in the reissue, or if the things were not covered by the original claims but are covered by the new or amended claims in the reissue. It gets a bit technical depending on broadening versus narrowing.
Okay. So it's tied to the history of the claims covering that specific item.
Right, and if the situation doesn't quite fit that absolute box, or if we're talking about more than just existing inventory.
Like, what if I hadn't finished making the product? Or I was just gearing up, investing in the factory?
Exactly. That's where the courts can invoke the second type, equitable intervening rights.
Equitable. So, based on fairness.
Precisely. This acknowledges that business isn't just about finished goods. It's about, major investments, planning, building the means of production. Equitable rights can be granted if a party made substantial preparation before the reissue happened. Think big investments, maybe building a factory, buying specialized tooling.
Stuff you can't just undo.
Right. Stuff based on the understanding of the original patent.
So this sounds like the court steps in and makes a judgment call. What counts as substantial preparation?
Well, imagine you're the CFO. You approved a, say, $50 million investment in a new production line, new machinery, facilities, maybe R&D, all based on the belief your planned product didn't infringe the original patent claims. That's serious commercial reliance. A court looking at that has the power, the equitable power, to balance fairness. They might say, okay, manufacturer, you can continue making or selling this product, maybe under certain conditions or for a certain time, even though it now technically infringes the reissued patent.
So they can tailor the remedy.
Yes, it's judicial discretion aimed at preventing the patentee's correction from totally wiping out legitimate business activities started in good faith. It's about protecting that future production based on past substantial investment.
Okay, that's a really clear distinction. Absolute rights protect the stuff you already did or have. Equitable rights protect what you invested heavily to do in the future. That feels like a necessary valve in the system.
It really is. It's crucial for making reissue work without causing massive commercial disruption.
All right, so we see the impact after a reissue is granted. But what about during the process? Say the patent owner files for reissue. They're basically admitting the original has a flaw, right? But what if they then, change their mind? Or the patent office rejects the changes? What if they abandon the reissue application? Does the original patent just spring back to life?
Yes, absolutely. And that's a really important procedural point. If a reissue application is just abandoned and no reissued patent ever actually grants from it, the original patent remains in full force.
Okay, that's good to know.
Yeah, the original patent's validity isn't automatically destroyed just because the owner tried to fix it and didn't succeed. It prevents this weird limbo where just filing for reissue kills your original patent.
So the actual act of surrender is tied strictly to success. When does that final definitive surrender happen? When is the original patent officially, legally gone?
The original patent is considered surrendered legally dead, basically only when two things happen. One, a reissued patent is actually granted. And two, crucially, there are no other related reissue applications still pending, like continuations or divisional stemming from that original reissue effort.
Okay, so it's grant plus no loose ends.
Exactly. It has to be a clean grant with nothing else from that family still cooking. And case law has been pretty clear on this timing. You see cases like McCormick harvesting way back, and more recently things like Pfizer v. Apotex. They really nail down that the surrender happens only upon the actual issuance of that reissue patent certificate.
That moment.
That's the point of no return. Once that new document issues, assuming no continuations are pending from before the grant, the old one is just void. Legally, it ceases to exist.
Wow. That makes the examination process inside the patent office seem incredibly high stakes for the owner. If they propose changes, maybe broaden or narrow claims, and that reissue gets granted.
Poof. The original patent is gone forever, replaced by the new one. It forces some really careful strategic thinking. Imagine deciding to cancel all your original claims and put in entirely new ones. You might get broader scope, maybe, but you lose any chance of those substantially identical claims for continuation.
You're sacrificing the original completely.
It's a massive bet, a non-reversible bet on the validity and scope of that brand new reissued patent.
That moment of issuance really is, like you said, a point of no return, a legal cliff edge. #tag outro. Okay, we've definitely covered some complex ground today, navigating through MPEP Section 1460 and the whole of patent reissue. It's clear that correcting a patent isn't just, filling out a form. It's a really high-stakes legal transaction.
Absolutely. It demands this delicate balancing act, letting the patent owner fix a real mistake while simultaneously protecting third parties through those intervening rights, both absolute and equitable. It's about fairness in commerce.
And we should also give a quick shout-out here. This whole audio series, breaking down the MPEP section by section, was organized by creative director Mike Shepard. His effort helps make this dense material a bit more accessible.
Definitely appreciated. Now, as you're thinking about all this, here's something to mull over, a sort of provocative thought. We talk about how surrender is immediate and non-reversible once the reissue grants, wiping out the original patent instantly, assuming no continuations are pending. How does knowing it's a final one-way street impact the patent owner's strategy during the examination? Does that fear of finality make them more cautious with claim changes? Or maybe more aggressive, figuring they have one shot to get it perfect?
That's a fascinating psychological and strategic question, isn't it? What calculations go into that decision? Well, thank you for joining us for this deep dive into patent reissues. And just a reminder for everyone listening, this summary was put together using AI tools. It's purely for general educational and informational purposes. It is absolutely not legal advice. For real guidance on these kinds of patent matters, you need to consult the official MPEP itself or talk to a qualified registered patent practitioner. We'll see you next time on the Deep Dive.